Ladies and gentlemen, welcome to our webinar as part of a serial commemoration on 25th anniversary of the HCCH 1996 Child Protection Convention in the Asia-Pacific region. This event is organized by the HCCH Regional Office for Asia and the Pacific, ROAP. It is my great pleasure to be moderating this event. Before we formally start the session, I would like to ask all of you to turn on the camera for the group photo instead of waiting till the end of the session. My colleague, Ms. Levi Gao, will help to take the photo for all of us. Thank you.
Okay, 3, 2, 1. One more photo, please. 3, 2, 1.
Is this okay?
Okay.
Okay, thank you. Thank you very much.
Thank you very much.
Thank you. Ladies and gentlemen, today's event focuses on the present, development, and future of the HCCH 1996 Child Protection Convention. And we are very pleased to have you all in our online Zoom meeting. Looking forward to have an intensive exchange of views and thoughts with all of you and the speakers. Our event is supposed to take about 75 minutes. We will listen to speeches by our distinguished experts for the next 1 hour or so. And afterwards, there will be Q&A session. Please kindly put in any comments or questions in the chat box so that I can read out the questions and comments to our speakers during the Q&A session for their answers. Last but not least, I would like to thank very much to our Secretary General of the HCCH, Dr. Christoph Bernasconi, for the great support for taking the time to participate in our activity and give the opening address. Now may I pass the floor to our Secretary General. Christopher, you have the floor.
Thank you very much, Professor Chow, and a heartfelt good morning from here in The Hague. It's shortly past 9:30 here in The Hague. Good morning, good afternoon, good evening to all of you. I'm sitting here in the conference room of the Permanent Bureau in the company of First Secretary Geraldine Goescola and Legal Officer Harry Cheng, both of whom, of course, work closely on the 1996 Child Protection Convention and other Children's Convention of the HCCH. It's really a delight to have you all on this seminar. Thank you very much for joining. A special thanks also again to you, dear Yun, for all the organization of this event, together with Levi Gao and Alex, who I also see. Thank you very much for making all these preparations. And a special thank you also to our 3 keynote speakers. It's really meaningful to have such distinguished experts from the region talking about this convention today. So many thanks to Professor Yuko Nishitani from Kyoto University in Japan, Professor Gyo-ho Lee from Chungang University in the Republic of Korea, and Professor Afifa Kusumadra from Brawijaya in Indonesia. Thank you very much indeed to all of you. We are delighted to have you with us today. This event is, in fact, the first in a series being held this fall here in the Northern Hemisphere to commemorate the 25th anniversary of the HCCH 1996 Child Protection Convention. This initiative is called HCCH Approach, the acronym standing for, I quote, advancing and promoting the protection of all children, end of quote. This row-up event complements 4 other activities: the Approach Essay Competition, the Approach Media and Design Competition, the Approach Global event on the 19th of October in a few weeks, and the Approach Regional event for central authorities that will be organized by our other regional office in Buenos Aires for Latin America and the Caribbean on the 29th of October. And I express my heartfelt thanks in particular also to Jerry and her team because they came up with this novel structure and a good name to sell the whole series of events relating to this important convention. These activities are indeed held to celebrate an important milestone of the convention, because we take this opportunity to reflect on the convention's history and acknowledge those who brought it from an idea to full fruition. And we chart out a path forward with the generous help of experts and supporters who have contributed to a multitude of HCCH projects to draw closer attention to the 1996 convention so as to help it reach its fullest potential. Maybe just the first quick look at the history of the convention. As is recalled in the explanatory report, the Child Protection Convention originated in a decision taken in May 1993 by the members of the HCCH represented at its 17th session. Their members sought to consider a possible update to, and indeed a revision of, an earlier HCCH convention, the 1961 Convention on the Powers of Authorities and the law applicable in respect of the protection of minors. A special commission was established, which over 3 meetings in 1994 and 1995 drew up a preliminary draft text which served as a basis for the discussions held at the 18th session here in The Hague in September and October 1996. It's actually quite remarkable to see how fast this important and complex, comprehensive convention was developed. At the 18th session, the drafting of the convention was entrusted to the second commission of the session with negotiations including 35 member states of the organization, 15 observer states, and 18 IGOs and NGOs. Mr. Adair Dyer, our former colleague, Deputy Secretary General, who of course was also absolutely instrumental for the development of the Child Abduction Convention, Adair prepared a substantial preliminary series of preliminary documents which greatly facilitated the work of this second commission, which was then chaired by Mr. Perung from Germany, and there were 2 vice chairs, William Duncan, representing Ireland, who of course would later join the Permanent Bureau and do great work here as a member of the Permanent Bureau in relation to all the children's conventions. And the other vice chair was Gloria de Hart from the United States of America. And the commission also elected Professor Paul Lagarde from France as who of course did a series of other explanatory reports for the HCCH. The draft convention on jurisdiction, applicable law, recognition and enforcement, and cooperation in respect of parental responsibility and measures for the protection of children was adopted unanimously by the member states at the plenary session of 18th October 1996, and actually received its first signature from Morocco the following day, on the 19th of October 1996. The convention then entered into force on the 1st of January 2002 upon the deposit of its third instrument of ratification, the first three being from the Czech Republic, Monaco, and Slovakia. Now, let's briefly take stock of the convention. Looking back on the ratification and accession timeline, the convention has enjoyed rather consistent increases in its number of contracting parties, with multiple actions taking place almost every year. The years 2010 and 11 were particularly active, with 16 new contracting parties representing both Europe and the Latin American region. In the Asia-Pacific region, Australia ratified the convention in 2003, while Fiji acceded to the convention in 2019. Most recently, the instrument entered into force for Costa Rica on the 1st of August of this year, Costa Rica becoming the 53rd contracting party. The practical handbook supporting this convention was published in 2014 and is now available on the HCCH website in less than 24 languages. The third of the modern HCCH children's conventions, the Child Protection Convention, covers a wide range of civil measures of protection for children in cross-border situations, from orders concerning parental responsibility and contact to alternative care to the protection of children's property. The core strength of this convention is its flexibility to be deployed for the best interests of the child under a variety of circumstances, with protection measures tailored to individual needs. There are also strong complementary features in the Child Protection Convention and the 1980 Child Abduction Convention, a point which is increasingly becoming clear to practitioners as well. For example, one technique is to use the Child Protection Convention's protection measures to bolster the safety of children who are undergoing a return procedure or are settling into different environments through operation of the Child Abduction Convention. And to this point, I note that the experts group on family agreements has recently concluded its 5th meeting to discuss its draft practical guide, a tool directed at legal representatives to help understand the recognition and enforcement of agreements that touch upon both these instruments, as well as the 2007 Child Support Convention. Circumstances coming under both all these three conventions, I should say, have the potential to be resolved with amicable solutions, and doing so often results in an agreement which needs to be rendered binding and enforceable across borders. This tool will undoubtedly help elucidate the complementary aspects of the conventions. Children represent half of the global population on the move between borders. While the COVID-19 pandemic has placed significant restrictions on the ability of cross-border families to interact. The protective mechanisms of the Child Protection Convention are as important as they have ever been. Unlocking the power of the Child Protection Convention requires attention on multiple fronts. understanding national and regional interests, which could be enhanced with this instrument, illustrating the utility of the instrument as its own product and as a complement to the 1980 Convention, and finding links to bring more contracting parties aboard. There are few states in the Asia and Pacific, with the exception of Australia and Fiji, that are party to the Child Protection Convention. This, despite the fact that, according to UNICEF, nearly 14 million of the world's international child migrants live in Asia. 14 million. This represents 39% of all migrant children. This shows that the large numbers of families and children living across borders and particularly migrating within the region shows that the 1996 Child Protection Convention can play a significant role in the region. Clearly, this is an area for improvement. National level promotion and expertise in this instrument, like that of our keynote speakers, are both essential to the effort of achieving greater understanding and participation in the 1996 Convention. Outreach of the Permanent Bureau, jointly conducted with ROAP, the regional office for Asia and Pacific, will continue to bring more members, more contracting parties to this instrument. And I really want to emphasize the importance of these efforts to try and bring in more states from your region into this convention. I would also encourage practitioners and experts to find value in the great diversity of cultures and legal traditions of the region, common, civil law, Islamic law, rather than viewing these differences as insurmountable facts that cannot be harmonized under one legal regime. Well, perhaps it would be more helpful to recognize that the inherent adaptability of the 1996 Convention is precisely the tool needed to achieve a system of child protection across the borders of the region. Accession or ratification of the Child Protection Convention will allow states in the region to fulfill their obligations under the UN Convention on the Rights of the Child, which all states in the region are party to. Becoming a party to the convention will also work towards fulfilling the UN SDGs and Agenda 2030 and ensure a future for children in the region, not only those in cross-border families, but also those moving across borders in the context of migration or displacement. In this context, I look forward to the three keynote speeches of today. The first will highlight the synergy between the 1996 Convention and the 1980 Convention, while the second and third speech will examine how the instrument could play a role in child protection for both the Republic of Korea and Indonesia, respectively. These discussions are the perfect opening to our HCCH approach activities and essential for building public awareness for the 1996 Child Protection Convention. Thank you for your attention.
Many thanks, Chris, for your warmest and touching address. So that's very important, I think, sets the solid stone, I think, for our further sessions. Child protection is a long-term and necessary issue. It is evolving with the development of the times, especially in the region of Asia and the Pacific. Today, we are very honored to have authoritative experts from the region to share their thoughts with us. Now, please allow me to introduce our first speaker, Professor Yuko Nishitani, who is Professor of International Private and Business Law at Kyoto University in Japan. She will deliver a speech entitled Synergy Between the 1996 Child Protection Convention and the 1980 Child Abduction Conventions. Let's welcome.
Excuse me, thank you very much for your kind introduction. I'd like to share my slides with you. Can you see that? Okay, so thank you very much for this great opportunity to give a talk on the 1996 convention and its relation to the 1980 Child Abduction Convention. As Christoph has mentioned, child protection has been playing a very important role at the Hague Conference on Private International Law. And since the 1980 Child Abduction Convention, there have been 4 instruments that have been built upon the administrative and judicial cooperation among contracting states. If we look at the number of contracting states in the Asia Pacific, we can count 15 states for the 1980 Child Abduction Convention, which is quite a high number. And also for the 1993 Inter-Country Adoption Convention, there are 13 contracting states. For 2007 Child Support Convention, there have not been so many states joining this instrument from the Asia Pacific. And this is also the case with the 1996 Child Protection Convention. And as Christoph has mentioned, states from Asia are waiting to join this instrument. And I'd like to explore how this convention works and what kind of advantages it has in child protection. 1996 Child Protection Convention is called the Global System for Child Protection. So its primary jurisdiction is at the child's habitual residence, and when the authority there takes certain protective measures or render custody or access order, it is recognized and enforced in other contracting states. And the central authorities of the contracting states work together. If the child is missing, they try to find out the whereabouts of the child together, and they exchange information. So they cooperate to effectively realize child protection in cross-border cases. The 1996 convention consists of 4 pillars. The first one is jurisdiction, which is primarily concentrated on the child's habitual residence. And there are several other additional specific jurisdiction grounds. Applicable rules is concentrated on the lex fori, or the habitual residence of the child, which usually coincides because the jurisdiction is primarily given to the child's habitual residence. And the third pillar is recognition and enforcement of foreign decisions. So once the contracting states renders a decision, it is automatically recognized and enforced in other contracting states in principle. And the cooperation through central authorities is the fourth pillar of the convention. And this is quite a complex and comprehensive set of rules that are provided by the 1996 convention. When it comes to the function of the 1996 convention, we can say that it ensures protection of children in international situations. So in terms of parental responsibilities, such as custody, access, and guardianship, they are fixed under the 1996 convention by exercising jurisdiction and applying the lex fori, or the law of the habitual residence of the child. And protective measures cover both private law measures and public law measures. So the scope of application is quite broad under the 1996 convention. And what is important about the function of the 1996 convention is its function of complementing the 1980 Child Abduction Convention. Under the 1980 Child Abduction Convention, when a child is habitually resident in state A, the contracting state, but is wrongfully removed to state B or wrongfully retained in state B, then the mechanism of return returning the child to state A is instituted under the 1980 convention. So under the 1980 Convention, it is presupposed that custody decision on the merits is left to the authorities of state A, where the child habitually resided before the abduction. And the state B, to which the child has been abducted, renders a return order when the authority in state B finds out that the child has been wrongfully removed or retained, and the conditions of returning the child are fulfilled, and there are no grounds for refusal under the 1980 Convention. Within the mechanism of this 1980 Convention, there are certain aspects that ought to be complemented by the 1996 Convention. That is, firstly, to what extent state A retains the jurisdiction on custody issues on the merits as state of former child's habitual residence. And the second aspect is to what extent state B can exercise jurisdiction on urgent protective orders or access orders to protect child while the child is staying in state B. In order to clarify why these two aspects are important, I'd like to give you an example from a Japanese recent court decision. On 30th March 2021, Yokohama Family Court renders an interesting decision. In this case, the couple and the daughter were all living in Singapore, and the couple divorced, and first the Singaporean court allocated joint custody to both parents. And there was also an exit order that the child could not be removed out of jurisdiction of Singapore without permission. Despite that, the mother decided to take the child out of Singapore and went to Japan. So there was wrongful removal of the child. After that, the father immediately applied again to the Singaporean court for sole custody, which was granted. So after the child abduction, the father obtained sole custody, and the court ordered that the child be surrendered and handed over to the father immediately. Then the father sought the recognition and enforcement of this Singaporean court order in Japan. Then the question came up whether the Singaporean court had indirect jurisdiction from the viewpoint of Japan. Because in order to render execution order in Japan, we have to see that the Singaporean court had indirect jurisdiction from our viewpoint. Both Singapore and Japan are contracting states of 1980 Convention, but none of them are party to the 1996 Convention. Interestingly enough, the Japanese judge said the domicile of the child was immediately transferred to Japan with the wrongful removal of the child from Singapore to Japan. So there was no domicile left of the child in Singapore, but it was immediately moved to Japan. However, the judge said because the couple had been living for almost 10 years in Singapore, and the Singaporean court was rendering different orders to regulate the custody of these couples. The Japanese judge said ultimately that indirect jurisdiction of the Singaporean court is granted ratione regis. So according to the reasonableness test we have in Japan. So as a result, the Japanese court said that we enforce the Singaporean custody order and the child ought to be given back to the father. But the question remains in such a case whether it was all right to say that the domicile of the child was immediately moved from Singapore to Japan, although it was a wrongful removal of the child. And in such a situation, actually, it would be more in line with the 1980 Convention to let the jurisdiction of Singapore on custody issues continue. Under the 1980 Convention, the return mechanism presupposes that the child ought to be returned immediately when the child is wrongfully removed to state B. by returning the child to State A should decide custody issues on the merits. And this envisages to deter foreign shopping by the taking parent. So the taking parent should not take advantage of the wrongful removal of the child. And also concurrent decisions in State A and State B ought to be avoided. But of course, after the lapse of certain time, the child may obtain indeed a new habitual residence in State B. So in order to balance these situations, the 1996 Convention actually gives a clear answer that jurisdiction of State A continues in principle in child abduction cases. But there are exceptions. One, if the left behind parent has acquiesced to the child abduction and said, all right, afterwards, then State B, to which the child has been removed to, obtains jurisdiction on custody issues. Or 1 year has lapsed after the child abduction and no request for return is pending in State B, and the child is now accustomed and settled in State B. Then again, under these conditions, exceptionally, the State B obtains jurisdiction on custody issues, but otherwise the jurisdiction ought to remain in State A. So this rule of the 1996 Convention actually complements the function of the 1980 Convention. And this has the background idea that the State A's jurisdiction ought to be decided in a clear manner. So it should not depend on whether State B rejects return application or not, but State A should retain jurisdiction unless these exceptional circumstances enter. So even if State B dismisses return application on grounds of grave risk for the child or the child's objection, unless these exceptional circumstances enter, the State A retains jurisdiction on custody issues. So this avoids arbitrary decisions of non-return by State B. They wanted to avoid that State B's authority just renders a decision of non-return to get jurisdiction on custody issues. So State A should be given the primary jurisdiction on custody issues. But in certain circumstances, custody decision by State A may not be appropriate in the eyes of State B. So if the State B has refused return application on grounds of grave risk for the child to be returned to State A, then even if State A renders custody decisions to hand over the child to the left behind parent, that decision of State A can still be refused recognition in State B. So 1996 Convention leaves this flexibility depending on the case, but complements in an appropriate way the functioning of the 1980 Convention's return mechanism. The second aspect of the 1996 Convention to support the return mechanism is allocating jurisdiction for urgent protective measures and access orders to State B. So even though the child has been wrongfully removed to State B, but while the return proceedings are still going on in State B, the left behind parent should be given the opportunity to see the child and have access to the child, or some urgent protective orders may be needed if the taking parent becomes sick and cannot take care of the child. So the 1996 Convention specifically gives jurisdiction for urgent protective measures to State B for such situations. And these urgent protective measures can be recognized in State A under the 1996 Convention. Of course, State A retains jurisdiction on custody issues on the merits. So State A can take different measures on custody issues anytime. But until State A renders a decision on custody on the merits, the urgent protective measures taken by State B remain effective in State A. And that ensures also safe and smooth return of the child because, for example, in domestic violent cases of the left behind father in state A, state B can take urgent protective measures that the taking parent, the mother, should be allowed to stay with the child in the shelter in state A. Or the father may not have access to the family, to the mother and the child, as protective order. And these measures can also be recognized in state A. And this ensures safe return order without obtaining mirror orders or safe harbor orders from state A. So this is also an advantage of the 1996 convention. As we have seen, the 1996 convention has great advantage of complementing the 1980 convention. And this allows coordination between contracting states in child abduction cases. And this is particularly important for Asian states that are party to the 1980 convention to have this mechanism of complementing the return mechanism. And of course, having uniform rules of cooperation coordination is advantageous under the 1996 convention. And this will also enhance the developments of domestic law in my eyes. So in order to join the 1996 convention, states need to have more effective enforcement measures and strengthen access orders, for example. And again, the 1996 convention can give positive influence and the impulse of changing the domestic law. It's not actually easy to adjust the domestic law to the 1996 convention. For example, in the case of Japan, we need to adapt new jurisdiction rules when we want to join the 1996 convention, not only in child abduction cases, but also different jurisdiction rules for ancillary jurisdiction in divorce cases, for example, and transfer of jurisdiction in certain cases is provided for. The 1996 convention must be also adapted in Japan, and applicable law rules also need to be changed because we still follow the nationality principle in Japan, whereas the 1996 convention is focusing on the habitual residence of the child. But still, although implementing the 1996 convention would require fundamental change in the way of thinking and adjustments of the domestic legal system, it is advantageous in various aspects and also in complementing the 1980 convention, which is very important for the member states of the 1980 convention. Ultimately, as Christoph mentioned, the 1989 UN Convention on the Rights of the Child requires effective mechanism of child protection. And actually the committee for UNCRC recommended Japan to ratify the 1996 convention in its final report of 2019. So it's, in my eyes, very important for us to seriously think about ratifying the 1996 convention. Thank you very much for your attention.
Thank you, Professor Nishitani, for your excellent speech. Now, I think, please allow me to introduce our next speaker, Professor Gyung-ho Lee from Chung-Ang University School of Law in Seoul for his keynote speech. His topic is the 1996 Child Protection Convention and its implications to Korean private international law. I can't wait to his inspiring ideas. So let's welcome Professor Lee, please.
Okay, thank you for your introduction. Also, I'd like to express my sincere gratitude to the HCCH Regional Office for Asia and the Pacific. My time is limited for the 15 minutes. So I'll start right away. Okay. Okay, today I want to illustrate the 3 parts. First is the number of married immigrants in Korea. Second is the current development in adoption, for the Hague Conventions in the child-related cases. Including the current development in the private international law and the civil procedure law. Finally, I will discuss the 1996 Child Protection Convention and its implication to Korean private international law. I think the number of the married immigrants in Korea has something to do with today's topic. So for the last 10 years, the annual number of the married Chinese immigrants are stable, but those are of the married immigrants from the Vietnam, Japan, and Philippines are slightly increasing. The rest of them is almost like the 3700 the international couples in the 2020. I think the fifth is ranked in Russia, and sixth is maybe United States, and the seventh is UK, something like that. But the problem is, okay, in this regard, actually, the Professor Nishitani mentioned that Korea is not Korea is a member of the Child Abduction Convention. It's true, and the Korea is implemented this Child Abduction Convention in the 2012. It was effective since the March 1st, 2013. Also, the Korea was signed Inter-Country Adoption Convention. However, it did not, the effective. Also, the Korea is ready to accede this convention, but it's still to to do. How about the Child Protection Convention? Korea is not a member of the convention. Actually, in Korea, in preparing the bill on the Korean private international law this year, the last year, in 2020, we already looked up to the 1996 Child Protection the convention. It's kind of in my words, we are the reverse engineering 1996 Child Protection Act, the convention, to provide, propose, submit the Korean bill on the Private International Act in 2020. In that situations, actually, we considered, even though the Korea acceded the 1996 Child Protection Conventions, most of the married couples are from the China, Vietnam, Japan, and the Philippines. So we think its effectiveness will be limited because Korea, China, Vietnam, Japan, and Philippines are not the contracting parties to the convention. This is the initial concern. Still, we'll look up to the 1996 Child Protection Convention to the draft the bill on the Korean private international law. That's right. So definitely 1996 Child Protection Convention was used as a reference for the bill. Okay, let me explain the current private international law. In this regard, we need to look up to the two laws. First one, Private International Act. The other is a Civil Procedure Act. Because the international jurisdiction and applicable law is governed by the private international law, whereas the recognition of a foreign judgment is governed by the Civil Procedure Act. That's why we need to look up to two laws. According to the Article 2 of the private international law, it gives a certain kind of general rule over international jurisdictions. Okay, in this regard, In case a party or the case a dispute in substantially related to the Republic of Korea, a court shall have the international jurisdiction. In this case, the court shall obey reasonable principles compatible to ideology of the allocation of international jurisdiction in determining the existence of substantive relations. The second paragraph of this article prescribes that a court shall determine whether or not it has the international jurisdiction in the light of the jurisdictional provisions of domestic laws, and shall take the full consideration of the unique nature of international jurisdiction in the light of the purport of the provision of paragraph 1. Actually, we have only one and the general principle of international jurisdictions, and the two special jurisdictions regarding the consumer contract and the employment contract. That's it. So we don't have any special provisions on the non-contentious family cases, including child, the parental responsibility and guardianships. According to the, when it comes to the applicable law, actually Article 45 and 48, the prescribed, the governing law in the parental authority and the guardianship. Interesting enough, actually, unlike the 1996 Child Protection Act, actually the Korean private international law are distinguished from the the governing law regarding parental authority under the Article 45, and the governing law based on what is the governing law based on the in connection with the guardianships. So this is the kind of the distinctive feature of the Korean private international law. Okay, last year, the bill of the Korean Act on the Private International Law was submitted by the Minister of Justice to the Korean National Assembly. Afterwards, the bill was referred to the Legislation and Judiciary Committee on August 10, 2020, brought up for the discussion before the committee in the September 21, 2020. As over April 1st, 2020, still, I think as of the September, today, the bill is still pending before the committee. But there's no, debated areas between the ruling party and opposing parties. So I'm expecting this bill will be passed this year. The purpose of this bill is the revised, the international jurisdiction provisions comprehensively, the leading, the choice of law rules, for the future. So I think the Ministry of the Justice took this, step-by-step approaches. So somehow, I think that the rules on the international jurisdiction is inconsistent with the choice of law rules in this regard. Anyway, the purpose of the bill, by preparing specific provisions for international jurisdictions on basis of accumulated precedents in relation to international jurisdictions, foreign laws, and international consensus. The bill is intended to increase the predictability and efficiency of the dispute resolutions for legal relations containing foreign elements such as multicultural families. So it includes the general principle of international jurisdictions, like the current the Article 2 of current private international law. It's almost the same, but it reflected Korean court precedents, including the wording that refers to fairness between the parties and correctness, expediency, and economic of judgment. That's it, but it's almost identical from the current private international law. Now it inserted the provisions on the general jurisdictions based on the habitual residence. Also, it has the the provisions on the international jurisdiction over the correlated cases. In this regard, Article 6, paragraph 4 of the bill prescribed that if the Korean court has the international jurisdiction over only the claims ancillary to the main claim, a plaintiff cannot institute a lawsuit for the main claim in cases related to paternity, parental authority, relationship between the parents and the children, and guardianships. So, the Korean private international law bill include the international jurisdictions of the correlated cases in terms of the parental responsibility and guardianships. I skipped this part. Also, there's the bill excluded what is it? International jurisdiction by the agreement or the appearance from the scope of provisions on the family-related cases. Also, it prescribed international jurisdiction to order any provisional measures. I'm not sure it include protective measures in the family cases, but somehow we can extend this provision to the protective measures in the non-contentious cases. Okay, interestingly enough, actually preparing drafting the bill, Korean private international law associations, the key members of the Korean private international law associations gathered to prepare drafting, the international jurisdictions in non-contentious cases. In this regard, we come up with the 1996 Child Protection Conventions. We, as a reference, we used it, but it's a long way to go. But we need to pass this bill last year, so we kind of in a rush. So we prescribed like this: the case related to kinship are governed by the Article 56 to 61 the bill, and then it went on to say that the general principles of international jurisdictions apply to non-contentious cases when special provisions on non-contentious cases like the exclusive ones. So it means we don't have any specific provisions on the international jurisdictions in non-contentious cases, such as the parental responsibility. And then we'll go back to the general principles for international jurisdictions, or we can interpret the general principles of international jurisdictions based on the 1996 Child Protection Conventions. Okay, the Article 59 of the bill prescribes like this. In a case related to parental authority, custody right or visitation right over a minor child or children, a Korean court has international jurisdiction over the case if any of the following conditions is met. First, the habitual residence of the child is located in the Republic of Korea. It completely consistent with the 1996 convention. Third, one of his or her parents and the child are Korean nationals. Is not consistent, but the wording is or, so basically is not inconsistent with the 1996 Child Protection Convention. Okay. Also, this Article 61 prescribes in terms of case related to guardianship of minor children, the Korean court has an international jurisdiction over the case if the habitual residence of a minor child is located in Korea, or the property of the minor child is located in Korea and it is necessary to protect him or her. Also this provision is consistent with the 1996 Child Protection Conventions, even though it's a little bit different. Okay, the Korean Civil Procedure Act prescribes the recognition of foreign judgment under 2000 Article 217. But in this case, it is prescribing the recognition of a foreign civil judgment. So we need to, prove whether the foreign non-contentious judgment is the civil judgment or not. Okay. Now, let's move on to the 1996 Child Protection Convention and its implication to Korean private international law. First, we will look up to the adulthood issues. 1996 Child Protection Convention, Article 2 of this convention and Article 4 of the Korean Civil Code is identical. So I can say the Korean law is consistent with the 1996 convention. How about the international jurisdictions? Both allows international jurisdiction over the case related to relation between the parent and child on basis of habitual residence of the child. In this sense, both are consistent. One is consistent with the other. So, as I mentioned before, the bill on the private international law, by and large, lacks Article 6 to 14 of the 1996 Child Protection Conventions. In this case, the Article 2 of the bill will be applied based on the Article 15, the paragraph 3 of the bill. So in applying Article 2 of the bill, 1996 Child Protection Convention is expected to be taken into account as a reference. How about the applicable law? In this regard, I think as the Professor Nishitani mentioned, both one is different from another. So in this regard, I think the Korea needs to revise the Korean private international law. As I mentioned before, the Korea is ready to, revise choiceable law rules after following the, revising the comprehensively revising the international jurisdiction provisions. So I don't know I think my guess is definitely the Korean legal community is ready to revise the Korean private international law. How about the recognition and enforcement of foreign judgment? The issue is whether application of Article 217 of the Korean Civil Procedure Act will be extended to the non-contentious family cases. In this regard, the separate legislation is necessary. So I believe the 1996 Child Protection Convention can be a good model for Korea in this regard. Thank you for the listening. This is all I have today. Thank you.
Many thanks, Professor Lee. Thank you very much for your excellent speech presentation. I think you obviously give us a very clear pictures about the private international law regime in South Korea and also its relationship to the child protection. So thank you. Ladies and gentlemen, if you have any questions or comments, please feel free to type in the chat box so we can also ask the speakers to respond at a later stage. So now, may I invite our third speaker, Professor Afifa Kusamadara from the Faculty of Law in Universitas Brawijaya to make a presentation in the title of The Protection of Children under Indonesian Private International Law. Professor, you have the floor.
Thank you, Professor Zhao. Let me share my screen. And then okay. Good morning, good afternoon, and good evening, ladies and gentlemen. Thank you for attending my presentation. Before I start my presentation, please allow me to thank Professor Yun Zhao and his team for inviting me to this webinar. With regard to the today's event, I would like to present several cases on the measures for child protection in Indonesia that leads to the conclusion that Indonesia should consider the accession to the 1996 Child Protection Convention. Indonesia has several laws that govern child protection, as you may see here. None of the laws govern the measures for protection of children in private international situations, such as they do not govern which state has jurisdiction, what the applicable law is, and none of the law also do not govern the recognition and enforcement of the measures for protection of children. Neither do the laws govern international cooperation for the protection of children. Now, I will present some private international cases related to measures for protection of children in Indonesia. In this first case, the parties were American citizens who lived in Jakarta. Their daughter, Lara Rose, was also born in Jakarta and she held American citizenship. In September 2007, Ms. Ralhan reported her husband to the Jakarta police for domestic violence. She alleged that her husband had caused trauma to their child. She also filed a petition for protection order in the Jakarta court for her and her daughter. The court granted them the protection order based on the Elimination of Domestic Violence Act 2004. In addition to that, the court revoked Mr. Kine's parental authority over his daughter and granted parental authority to Ms. Ralhan and Lara's maternal grandparents who also live in Jakarta. Now, I will analyze the measures for child protection taken by the Jakarta court in this case. Based on the jurisdiction of the court, the law applied by the court, and the recognition and enforcement of such measures. In exercising its jurisdiction, when the court temporarily revoked Mr. Kain's parental authority, the court did not explain the basis of its jurisdiction. In its judgment, the Jakarta court did not mention either the habitual residence of the child or the presence of the child as the basis of its jurisdiction. The court applied its own law, namely the Elimination of Domestic Violence Act, when exercising jurisdiction to revoke Mr. Kain's parental authority over his daughter. Actually, the Elimination of Domestic Violence Act does not govern either the restriction of parental responsibility or rights of custody or access, because the scope of the act is criminal law, not private law. Mr. Kain appealed to the Supreme Court and objected to the application of the Elimination of Domestic Violence Act to the revocation of his parental authority. He argued that the revocation of his parental authority should be based on a different law, namely the Child Protection Act 2002 that required different procedures. The Indonesian Supreme Court dismissed Mr. Kain's appeal. Regarding the recognition and enforcement of measures taken by the Jakarta court, the court does not expect that its measures will be recognized and enforced outside Indonesia, including in the United States, because Indonesian civil procedure law, Article 431 Res for Ordering, provides that Indonesian judgments are valid and enforceable only in Indonesia. In the case 2, the parties were an Indonesian husband of the two children. During the divorce process, the Indonesian father abducted the children and brought them to Jakarta. And the father filed for divorce and sole custody for his children in a Jakarta court. Eventually, the German mother responded and claimed that the German court had granted her a temporary custody of the two children. She also explained to the Jakarta court that the children suffered stress and parental alienation syndrome caused by the abduction. The South Jakarta court refused to recognize the provisional ruling made by the court in Germany, in which the two children were habitually resident. The Jakarta court granted a divorce to the couple and granted each parent a custody of one of their children, as you read in the slides here. Like the case 1, I would like to analyze the measures for child protection taken by the court in this case. The jurisdiction of court in this case was clearly not based on the habitual residence of the children. With regard to the law applied by the court applied its own law, namely Marriage Act 1974 that governs the custody dispute after a divorce. It is clear that the court considered the case as merely a custody dispute, not the case of child protection to wrongful removal or retention of children. The court's decision has been criticized because it did not take into account the best interests of the children. It separated two siblings from each other and did not consider the children's daily language and the sharp different environment between Germany and Indonesia. Regarding recognition and enforcement of measures for child protection, in principle, foreign judgments are not recognized and enforced in Indonesia pursuant to Article 436 res per ordering. In case 3, an American father adopted her child who was habitually resident in Indonesia when the child and her Indonesian mother visited the father in Vietnam. The father retained the child in a hiding place somewhere in Vietnam. The mother immediately reported the abduction to the Vietnam police and then to the Indonesian Consulate General Office in Ho Chi Minh. When they found the hiding place, the Indonesian consulate mediated the couple, but the American father refused to return their daughter to her mother because he did not recognize the judgment made by the Jakarta Religious Court that granted the custody to the mother. However, the Vietnamese police was able to get back the child and return her to her Indonesian mother. From this case, we learned that the effort to protect the child was mostly made by the Indonesian Consulate General Office in Vietnam with the help of the Vietnamese police, because there was no international cooperation for the protection of children between Indonesia and Vietnam. With regard to the draft bill of Indonesian private international law that will be introduced to Parliament next year, it does not contain provisions that govern the measures for protection of children and their property in private international situations. In conclusion, Indonesia should consider the accession to the 1996 Child Protection Convention because Indonesia does not have laws that govern the measures for child protection in international situations. And the accession could make Indonesian courts and Indonesian authorities respect the child's habitual residence and the child's best interest. The convention is also needed to establish cooperation
Okay, so thank you, Professor Kusumadara, for your excellent presentation. I think you obviously give us a vivid picture of Indonesian legal regime in relation to child protection through real cases, which is, of course, I think really very helpful for our understanding. I saw that that questions from Ms. Hon Ngo Bu from the Ministry of Justice of Vietnam. In view of the time constraints, I have privately communicated with Dr. Geraldine Gore-Escola, who have very kindly agreed to reply the question through email after the webinar. So I think we will not hold the Q&A sessions now. So now we will move to the last part of our webinar. Let's welcome Dr. Geraldine Gore-Escola, our first secretary of the HCCH Permanent Bureau, to give us the closing remarks. Jerry, please.
Hello, and good morning, good afternoon, and good evening to everyone. It's a pleasure to be here and a privilege to speak after so many esteemed colleagues have actually taken the floor. I won't keep you today except to say, of course, if you have a whole bunch of questions on the convention, we look at that very well because it shows the interest in the convention. So please do write the Permanent Bureau and we'd be happy to take any questions you may have. On that note, allow me to thank, of course, the keynote speakers, in particular, Professor Yuko Nishitani, domo arigatou gozaimasu, Professor Gyoho Lee, Gamsa Hamnida, and Professor Afifa Kusumadra. Terima kasih banyak for being with us today and for speaking to us about different issues that you find in relation to child protection and cross-border child protection in your countries. I take in particular the first case that Professor Kusumadra spoke about, which is Purmina versus Jonathan Kine, and the conclusion that the court actually got to, that Indonesian courts do not expect the recognition and enforcement of its decisions outside of its jurisdiction. Of course, there's optimism because of the draft bill of Indonesia on private international law that will be introduced next year. Now, for these reasons, actually, the opinions of courts that their decisions would not have any sort of force or recognition outside of their jurisdiction, this is one of the reasons why the 1996 Child Protection Convention is so important, not just to individual countries, but to the region as a whole and to the world as well. Now, Professor Yuko Nishitani referred to the 1996 Child Protection Convention as the global system for child protection, and that's exactly what it is. The convention has the acknowledgement that there are clear challenges in private international law mechanisms in some countries, and the adoption of this 1996 Child Protection Convention brings immediate benefits by resolving these challenges. It is a powerful tool in eliminating legal obstacles to the protection of children, as exemplified by the title and the instrument itself. It has to do with jurisdiction, applicable law, recognition and enforcement, and cooperation in respect of parental responsibility and protection of children. This allows the convention to cut right straight to the core of questions of private international law. It clears away barriers to allow the best placed state to have jurisdiction over the child and the matters relating to that child, so that also their decision can have the broadest possible reach outside of the borders of their jurisdiction. Now, of course, when accepting the benefits of the convention, there are also perhaps some growing pains into the convention. Professor Nishitani and Professor Lee have alluded to some of these, which in particular has to do with the difference in the connecting factors that each of your domestic jurisdiction may give to cases, in particular the question of nationality as a factor. Now, as Professor Lee has presented, nationality in Korea is given as a connecting factor in the alternative, as well as the habitual residence of the child. And that to me already is a great step forward in seeing how the 1996 convention actually can apply in the domestic systems of Korea, as well as in Japan. Now, as my Secretary General mentioned, and again was reiterated by Professor Nishitani, practitioners are increasingly recognizing the complementarity of the 1996 Child Protection Convention with the 1980 Child Abduction Convention. There are also, of course, complementarities between the 1996 Convention and the United Nations Convention on the Rights of the Child. The 1996 Convention offers practical rules that serve an overarching purpose, implementing the United Nations Convention and the obligation obligation of states, parties to this convention, to take actions in the best interest of the child. Now, we cannot view these conventions in a vacuum. We have to look at them as a legal framework as a whole, and the lattice on which we build the protection of the most vulnerable in our societies, our children. And so the 1996 Convention does provide various practical elements and mechanisms that allow the implementation of these obligations. In the same vein, the Child Abduction and Child Protection Conventions work together. They have synergies between the two instruments, and they can be deployed together to guarantee the best interests of the child. Now, we are also working, of course, on the practical guide on family agreements here at the Permanent Bureau and at the HCCH, and we hope that this guide will be an important milestone in improving the clarity of how these conventions, together with the Child Support Convention, would work together, and to promote alternative dispute resolution mechanisms such as mediation and the arrival to an agreement in a family unit through voluntary means. Now, Professor Nishitani did speak about the use of the 1996 Convention, specifically in various different case use scenarios: parental disputes over custody and contact, the reinforcement of the protection of children in relation to child abduction situations. There are also, of course, the usage of this 1996 Convention in relation to unaccompanied minors who find themselves across a border, as well as alternative care across borders, even in alternative situations which are not usually foreseen. So, for example, in the 1996 Convention, we look specifically to the institution of kafala, which is extremely important by way of Islamic law. You've heard my Secretary General mention earlier this morning, or this afternoon for you, that in terms of origin and destination, there are some 14 million of the world's international child migrants that live in Asia. 14 million is twice the population, the entire population of Hong Kong. And of course, UNSCAP has also said that some close to 50 million migrants from Asia-Pacific countries move to other countries within the region. So just within the Asia and the Pacific region, we're speaking about the entire population of Korea getting up and moving across borders. We're seeing those numbers increase. And with those numbers increasing, we're also seeing more children across borders that need to be protected. For that reason, the increasing rates of international mobility, together with growing concerns of protection of children across borders, means it is so important to raise awareness of the 1996 Child Protection Convention and to increase accessions and ratification rates. I've heard some of our speakers say today that even if their countries or even if their jurisdictions were to accede to the 1996 Convention, that there would be very little impact, because the other corridor states, so the other states where they see a lot of child migration, are not parties to it. Now, I would like to challenge that a bit and perhaps say that all it takes is one to start the ball rolling. If all of the countries keep waiting for everybody else to join before they start considering acceding to the convention, absolutely nobody would move. And perhaps all it takes is one visionary state to decide to sign up to this convention, to properly implement the mechanisms of this convention for all the other states in the region to sign on. I'd like to leave you with that thought, and also to perhaps leave you with an invitation to join us on the other events in this series. As my Secretary General has mentioned early this morning, there are two competitions that are closing 5 o'clock on Central European time this Friday, an essay competition and a design and media competition. We are also holding the global event for the HCCH Approach Initiative on the 19th of October, the exact 25th birthday of this convention. And the Regional Office for Latin America and the Caribbean will also hold a special event for its central authorities on the 29th of October. On that note, I thank you very much, also in particular to my colleagues in the Regional Office for Asia and the Pacific, Professor Zhao, Legal Officer Levi Gao, and Alex. Thank you so much for organizing this and for taking such good care of us. Have a lovely rest of your day, and I give it back to the floor to you now, Yun. Thank you so much.
Thank you, Jerry, I think, for your inspiring remarks, which brings the webinar to a perfect end. I would like to take the opportunity to thank the three excellent speakers for their presentations. I would also like to thank Christoph and Jerry for opening and closing the webinar. I would also like to thank Levi and also Alex for hard working, I think, to make this webinar, I think, a successful one. Ladies and gentlemen, I would also like to thank all of you for your active participation and support. Your attendance and support made this event very successful. And I look forward to seeing you all in a future event. Thank you very much.